More than 5 times?
I don't know.
At least once or twice, but you don't know.
I think I said I know I talked to him at least once or twice. But how many times, I don't know.
These were telephone conversations, right?
Pretty much, yes.
And during these telephone conversations, it was just you and Mr. Preston on the phone. Is that right?
Yes.
And during those telephone conversations, you talked with Mr. Preston about where you were going with the numbers on the severance package, correct?
Probably, yes.
And where you were going meant where the personnel committee was going. Is that fair to say?
Not necessarily.
Might have been just where you personally were going. Is that right?
That's correct.
So during these telephone conversations with Mr. Preston in advance of the November 18, 2008 meeting, you agree that you were discussing his anticipatory breach claim against the county, correct?
You're going to state that again.
So basically you would agree then that prior to the November 18, 2008 meeting of county council, you had discussions with Mr. Preston about his anticipatory breach claim against the county.
I had discussions, I think I said, concerning maybe numbers.
And those numbers related to his severance agreement, correct?
Right.
And you thought it helped your decision-making process to have these conversations with Mr. Preston, fair to say?
No, I wouldn't say it affected my decision-making process.
Would you say it helped your decision-making process?
It was just a bit of the information. I would say it affected my decision, yea or nay.
Offer the witness his deposition transcript to ask him about what he just said.
Sure.
You want to
send that up to him?
Yeah, I can hand him a copy if you want the original.
Hand it to me first.
Yes, sir.
Thank you. Record will reflect that I've been handed the original, what appears to be the original of the deposition of Larry Eugene Greer, dated October 8th, 2012. It is a sealed document. Does the defense have any objection to my presenting this to the witness?
Your Honor, he did not wait to sign his deposition. He is still within the period of time to sign his deposition. So, subject
You
to
want to
that
ask him
objection.
about that if he wishes to read it and sign before he's asked about it?
Well, I think in fairness, Your Honor, if he certainly can look at the transcript, if he has amendments he'd like to make, he can take the time to tell us what they are. I would suggest maybe the best, most efficient way would be to do that passage by passage, rather than try to do the
Well, I'm going to give the witness the opportunity to read whatever he's referred to. If he wishes to make changes, I will allow him to do that. He has the right to do that within the time of reading and signing. My question is, do you have an objection about opening this and presenting it to the witness? All right. The record will reflect that I'm raising the seal on the document. And if you'll pass that to the witness for me, Mr. Clerk. Thank you very much. Greer, what you're being handed is the original, what appears to be the original of your deposition. It was taken on the date that I indicated in October of this year, and that's being offered to you so that you can review the testimony. You may proceed, Mr. Testimony.
Thank you, Your Honor. Mr. Greer, what I'd like to do is just direct your attention to page 99 of the transcript that's in front of you. And in particular, I'd like you to look at lines 7 through 12 of that transcript. Just let me know when we get there.
Excuse me, page 99, where?
Lines 7 through 12. It's on the screen. I don't know if that helps you any, but if you want to read it from the transcript there, that's also fine. And we appreciate, Mr. Greer, that you have now had the opportunity to review the transcript to see if you want to correct any errors in there, typographical errors or other errors.
What I'm going to ask you to do is refer him to the area you intended to ask about and then give him a chance to read it.
Okay.
Then ask him if he wishes to make any changes or corrections.
So, Mr. Greer, if you look at the lines 7 through 12 in the deposition transcript, my first question then would be, once you have the chance to look at it, is there anything about that testimony that you would like to change?
I'm assuming you're asking me this question based on the response to your last question.
Correct.
And the answer I gave you to, I guess, your second question there in line 11 says, I think so because it helped me in my decision-making process. My answer to your question in this courtroom today is in no way contradicts that. I still, even though I may have information or gather information, I still am a man of my own and I make my own decisions based on what I know and believe and not on what someone else has told me. So as far as making any changes in this deposition, I would say it may have helped me, but it didn't change my mind one way or the other, neither yay nor nay.
And I'll move on to some other questions, Mr. Greer, and you may need to refer to that later, so you can keep it in front of you. Mr. Wilson, at some point in time, Mr. Greer, would you agree Mr. Wilson asked you to locate funds within the Anderson County budget to use for Mr. Preston's severance payout?
I would.
And when he asked you to do this, he told you to look for approximately $1.14 million, is that right?
I believe that's correct.
And once you were asked to do this, you went to Rita Davis in the county finance department, is that correct?
I think that's correct.
And you did this, made this request of the finance department within a day or two of Mr. Wilson's request to you, fair enough?
I couldn't tell you.
And I may have to show you a document, and I'm happy to do so, but do you remember that Ms. Davis had a memo that I showed you that had a date of November 3rd, 2008 on it?
I remember you showing that to me during the deposition, I believe.
Does that refresh your recollection that you would have been asking Ms. Davis about whether there was $1.14 million available in the budget around November 3rd, 2008?
I think when I spoke to Ms. Davis the first time, I asked her to provide me with budgetary information that would indicate the amounts left in various fund accounts.
And the reason you were asking her for that information was because you were looking to figure out if there was $1.14 million, give or take, that could support a severance payout to Mr. Preston.
That's correct.
And that happened on or about November 3rd.
According to that letter.
So as early as November 3rd of 2008, you knew that Mr. Wilson, as chair of the personnel committee, was looking for approximately $1.14 million in the county budget that might be used for a severance payout to Mr. Preston.
Evidently.
Before the November 18th meeting of county council, you agree with me that Mr. Wilson provided you with a working copy of Mr. Preston's proposed severance agreement, right?
He did.
You don't remember when exactly you got that, do you?
No, I did not.
You agree with me that you never shared that working copy of the severance agreement with either Mr. Waldron or Ms. Wilson?
You're going to have to state your question again.
You would agree with me that you never shared that working copy of the severance agreement with Mr. Waldron or Ms. Wilson, don't you?
I would agree with that.
And in fact, you disposed of that working copy of Mr. Preston's severance agreement before the November 18th meeting, correct?
I would say so.
Before the November 18, 2008 council meeting, you agreed that you talked with each of the other 4 members of county council who ended up voting with you in favor of the agreement, correct?
You're saying before November the 18th that I talked to each of the other 4 council members.
Right.
I did.
And you talked with each of them more than one time before the meeting occurred, correct?
Probably.
You did not talk with Ms. Wilson about the severance agreement in advance of the November 18th meeting, did you?
I did not.
And you did not talk with Mr. Waldron about it either, did you?
I did not.
You were interested in knowing in advance of the November 18th meeting whether or not you had sufficient votes to approve the severance agreement for Mr. Preston, correct?
Yes.
And in fact, before the meeting started on November 18, 2008, because you had talked with the other 4 individuals who voted in favor of the agreement, you thought you had enough votes to pass it, didn't you?
I thought so, but was never sure.
Do you recall, well, let me ask it this way. Before the November 18, 2008 meeting, do you recall that it was mentioned between you and 1 or 2 other council members that you would be presenting the financial side of the severance agreement at the meeting?
That was part of one or more discussions.
And by you, it means Mr. Greer was going to be the person at the meeting that was going to present the financial side, correct?
That's correct.
And that was determined in advance of the meeting, fair enough?
Had to be.
Do you recall discussing having one of the county members raise a motion to reconsider so that you could prevent future reconsideration of the severance agreement?
State your question again, please.
Do you recall prior to the November 18th meeting happening that 1 or more of the county council members knew that they were going to raise a motion to reconsider so that you could prevent future reconsideration of the agreement?
Do I recall it?
Right.
No.
Before the meeting had occurred, before the November 18th meeting, you had discussed with Gracie Floyd that she would be the person to present the proposed contract to hire Mr. Cunningham to be the new county administrator, right?
To my recollection, she had requested to present it.
And would you agree with me that before the November 18th, 2008 meeting occurred, you had discussed that very thing with Ms. Floyd?
I don't know if there was a discussion, it's just a comment made that that's what she wanted to do, and that was the end of it.
You had no problem with Ms. Floyd being the person to present that proposed contract, did you?
No.
And that was something that was determined in advance of the November 18th meeting, correct?
I'm saying yes.
In fact, you were involved in 2 meetings before November 18th to discuss hiring Mr. Cunningham, weren't you?
Yes,
One of the meetings was at O'Charlie's in Greenwood.
that's correct.
And at that meeting, you, Mr. Wilson, Ms. Floyd, and Mr. Cunningham were all present, correct?
Mr. Wilson, Ms. Floyd, Mr. Cunningham, and myself, that's correct.
At that meeting, would you agree that you reached a consensus to hire Mr. Cunningham?
I'm sorry.
I'm sorry, I didn't ask that very well. Would you agree with me that at that meeting at O'Charlie's in Greenwood, the folks in attendance pretty much reached a consensus that Mr. Cunningham should be hired as the next county administrator?
I couldn't answer that.
Let me show you, if I can refer you to page 132 of your transcript that's in front of you. Just let me know when you get there.
All right?
If you look between lines 132, starting at line 9, actually you can just start at the beginning of the page. Just to give you the opportunity to review that testimony. 132 and then 133 to line 12.
Okay, we're on page 132.
That's right, starting at line 1.
Line 1 going through what line?
133, line 12.
Okay, and what's your question?
So the first question would be, now that you've had a chance to look at that portion of your deposition transcript, is there anything about that portion of the deposition transcript that you think is in error or should be corrected?
I think your question in the transcript was confusing
Okay.
because you've rolled what occurred in 2 meetings into one.
Okay, and I think I know what you're saying. Let me ask a better question perhaps. Would you agree with me, Mr. Greer, that between the first and second meeting that you mentioned, where Mr. Cunningham was discussed, between the 2 of those meetings, at some point in time, a consensus was reached by the people at those meetings that Mr. Cunningham should be hired as the next county administrator?
At the conclusion of the second meeting, which was held at Ruby Tuesdays in Greenwood, where Mr. Wilson, myself, and Mr. Cunningham were present. I think a consensus was reached at that time, provided that the contractual parts were hammered out, that we had reached a consensus, yes.
And and I don't know which one, so you tell me, but at one of those meetings, would you agree that after the meeting was over, you provided or got Mr. Cunningham a copy of Mr. Preston's existing employment agreement?
I may have had one to give him, but I think he already had one, I'm not sure.
Would you agree that at some point, at or after those 2 meetings that you had discussing Mr. Cunningham came into possession of the agreement of Mr. Preston?
I would say he probably had one, yes.
And the reason for that was that you felt like it would be a good idea to use Mr. Preston's existing employment agreement as a model for the one to be proposed to Mr. Cunningham. Is that fair?
That's fair.
Would you agree with me that the contract that was ultimately offered to Mr. Cunningham at the November 18th meeting was a contract that was drafted by Mr. Tom Martin, county attorney, at the direction of Mr. Preston?
To the best of my knowledge, that's correct.
So it would be fair to say then that Mr. Preston knew that the contract for Mr. Cunningham was being prepared in advance of the November 18th meeting, correct?
That's
Objection, Your Honor, calls for speculation.
I'll ask you to set a foundation for that knowledge.
He just said, Your Honor, his knowledge was that Mr. Martin prepared the contract at the direction of Mr. Preston.
But you're asking him to state what was in Mr. Preston's mind at that time, and I have not heard that he discussed that process with Mr. Preston and had some knowledge of what was in his mind at that time.
Let me ask.
So maybe you ought to rephrase the question as to whether he had knowledge of what was in Mr. Preston's mind. You know, that you can prove what people intend to do or what their knowledge is by circumstantial evidence. And then it's up to the finder of fact to draw inferences from that. And generally, I don't allow witnesses to testify as to what's in someone else's mind. They can testify about the facts and circumstances that existed at that time, from which me, the finder of fact, might be able to draw inferences. You understand my rule?
Yes, that's
all right. You may proceed.
So, Mr. Greer, if I'm understanding you correctly, you were aware that the contract for Mr. Cunningham, the one that was going to be proposed to him on November 18th, was being drafted by Mr. Martin at the direction of Mr. Preston.
That calls for hearsay, Your Honor. It may be being drafted by Mr. Martin, but unless this witness, he's asking this witness to testify about what Mr. Martin said that Mr. Preston told him to do.
I want to allow you to ask questions as to what Mr. Martin may have told Mr. Preston to do. Let's see Mr. President. In some way, and observe what went on.
Let me try it a different way. Mr. Greer, did you understand that a contract to hire Mr. Cunningham was being drafted in advance of the November 18th meeting?
I was.
And who was drafting?
Mr. Martin.
And do you know how it was that Mr. Martin was asked to draft the contract?
I think he was, did I know how Mr. Martin? Ask your question again.
Do you know how it came to be that Mr. Preston was asked to draft the contract for Mr. Cunningham?
Objection, Your Honor. I don't believe that those facts are in the evidence.
You
Mr. Preston.
misstated. You said that the contract was being drawn by Mr. Preston.
Yes, I did mistake.
You misstated. So and she caught you. So if you would re-ask the question.
A lot of names in my head. Mr. Greer, let me ask this the right way, I hope, and that is,
This is a tough process, but we're gonna get through
Do
it.
you-
Go ahead.
do you know how it came to be that Mr. Martin was drafting the proposed contract for Mr. Cunningham? Or for Mr. Cunningham's employment?
I'm assuming, excuse me, I'm assuming he was asked to draft it by Mr. Cunningham.
And so you don't know one way or another how it came to be that Mr. Martin was drafting the contract. Is that fair?
You're asking me to recall things that happened 4 years ago.
Believe me, I'm not.
And I am doing my dead level best to answer you truthfully. I will say this, Mr. Martin was a county employee. Council members cannot instruct a county employee under home rule to do anything. An individual council member can't. It must be by a majority of council under home rule. So no council member could instruct Mr. Martin to do anything.
So based on that response, would it be fair for me to say that you knew no one on the personnel committee, none of the county council members instructing Mr. Martin to draft the contract for Mr. Cunningham, correct?
Objection calls for speculation.
I'll ask if he had knowledge of that. I'll ask allow that question. Go ahead.
Do I have knowledge if anyone on the personnel committee instructed Mr. Martin to do that?
Right.
Not that I'm aware of or recall.
And at that time frame, in November of 2008, in your view, who were the people who could instruct Mr. Martin to draft the contract? If not county council members, then who could?
The administrator.
And at some point in time, did you become aware that a contract for the proposed employment of Mr. Cunningham was actually drafted?
Yes,
How did you become aware of that?
it was handed to me.
By who?
I believe it was Mr. Cunningham, but I can't say for sure at this time.
Did you know when that was?
The night of November 18th.
And what did you do with the contract? This is a proposed contract now for Mr. Cunningham. What did you do with it when you received it?
It was in an envelope